Now I'm going to introduce you to this program. This is our Regulators Roundtable. It's moderated by Richard Powers, who's a partner at Crescent Mader Powers, where his practice focuses on affirmative antitrust litigation, agency advocacy, and representing complainants and whistleblowers. He previously served as the Acting Assistant Attorney General for the Department of Justice Antitrust Division in 2021, and he was the head of the criminal antitrust enforcement at the division for 4.5 years. Now I'll turn it over to Richard.
Great, thanks, Sean. Well, good morning. It's good to be here with everyone. And it's absolutely my privilege to share the stage with our distinguished panelists that are joining us here today, and I will introduce them now. So I will start with Doha Mekki on the end. Doha serves as the Principal Deputy Assistant Attorney General at the Department of Justice Antitrust Division. She's the number 2 official there. In that role, Doha supervises more than 350 attorneys who investigate and prosecute civil and criminal violations of federal antitrust and other competition laws. She's responsible for overseeing the division's civil enforcement, criminal enforcement, litigation, domestic and international policy, advocacy, and economic analysis programs, as well as the division's operations. So she's a very busy person. Sitting next to Doha, we have Lisa Miller, who serves as the Deputy Assistant Attorney General for the Department of Justice's Criminal Division. And she has responsibility for overseeing the more than 200 prosecutors working in the fraud section and the appellate section, including the section's overseeing the section's most important prosecutions, corporate prosecutions, and corporate policy issues. Prior to her appointment, Lisa was a senior prosecutor in the fraud section, having served as the chief of the Market Integrity and Major Frauds Unit, and as the principal assistant chief of the Healthcare Fraud Strike Force. And seated next to me is Laura Alexander. Laura is an experienced antitrust litigator, currently serving as the deputy director in the FTC's Bureau of Competition. In that role, she helps supervise more than 350 attorneys nationwide who, alongside Doha and the Department's Antitrust Division, enforce the nation's antitrust laws. And they also, the FTC's Bureau of Competition also serves as a resource for policymakers on all manner of competition issues. So again, a very distinguished panel here today. So why don't I'm gonna start very briefly with the backdrop, and then I'm gonna turn it over to our speakers. So, you know, under the Biden administration, you know, we've seen a number of fundamental changes to how the Department of Justice and the FTC approaches corporate enforcement. With respect to antitrust enforcement, in competition, the administration has really sought to promote competition in the American economy. They've tried to do that using a variety of tools. In terms of litigation, the FTC and the DOJ have brought a record number of cases to trial, challenging everything from mergers to monopolies to various forms of collusion. They've use their regulatory powers to implement regulations, and I think most notably, and I'm sure we will hear about today, you know, the recent ban on employer and employee non-compete agreements. And then they've also been working to form partnerships across the federal government, working with agencies that really touch all parts of the economy. We've also seen from the Department of Justice and the FTC changes to how they detect, seek out corporate misconduct, and that includes things like monopolization and cartels, in addition to, I think, what we think of with that, which are the traditional forms of serious fraud or various types of corruption. And they've tried to, they're using tools such as whistleblower programs, incentivizing complainants, corporate complainants, as well as voluntary self-disclosure programs. And then with respect to compliance, corporate compliance, I think we've seen, and we've all seen this in our practices in our companies, an emphasis on ensuring programs account for modern business realities. And by that, I think, really what I mean is things like ephemeral messaging, online collaboration tools, and the use of AI and algorithm-based tools in business. And so we're going to cover all of those topics. I will stop talking now, but I think it's fair to say we are fortunate to have three of the most senior officials at the Department of Justice and the FTC who are responsible for driving these changes and can talk about what it means for companies, for in-house professionals, and for the lawyers who are advising them. So with that, let me turn it over to Laura, who's going to get us started.
Thanks, Richard, and thanks to the ABA for inviting me to be here today, and to all of you for coming here to listen. It's really a pleasure to be with you all. First, of course, the disclaimer that today I speak only for myself and not on behalf of the Federal Trade Commission or any particular commissioner. You know, I was asked to sort of give a little overview of what our goals and enforcement priorities are at the FTC, and particularly at the Bureau of Competition. And so, you know, from my perspective, at a high level, there are several areas of focus that are guiding our priorities and initiatives in the Bureau of Competition and at the FTC more generally. The first of which is simply to make use of the full range of tools that Congress has bestowed on us to protect markets and consumers from threats to competition. So that includes going after conduct, not just like price fixing, but also things like the use of non-compete agreements or price discrimination that might threaten competition. It also includes reaching out to protect not just consumers, but also looking at protecting workers and other groups from threats to competition. Another overarching goal has been to use antitrust tools to confront the challenges to competition that are presented by modern markets. That includes looking at market practices and conduct, such as serial acquisitions or threats to non-price competition, and also includes looking at things, modern technology threats, such as the threats to competition from the use of algorithms or generative AI, as Richard mentioned. Another overarching goal at the FTC and at the Bureau is to use all the tools in the toolbox that we have. So, of course, that includes litigation, including enforcement actions to enforce remedies that have already been determined, but it also includes Rule 6b studies and rulemakings and collaborating with our federal, state, and international partners to address threats to competition. Now, I know we plan to talk more about the enforcement goals in particular and strategies, so I wanted to just take this opportunity to highlight several of the policy initiatives that we've undertaken at the FTC in recent days. With thanks to Doha, in December, we and DOJ finalized new merger guidelines. Those guidelines were updated to reflect the realities of the modern economy and to be open and transparent about the tools and approaches that we use at the agencies in analyzing transactions. As Richard mentioned, the FTC also just last month issued a ban on non-competes through a rulemaking, non-competes in the context of employment. In our view, this is a widespread practice that empirical literature shows depresses wages, reduces worker mobility, and hampers innovation. And so that rule was just finalized. We also issued a policy statement relating to the improper listing of patents in the Orange Book and challenged over 400 patent listings and sent warning letters to 14 companies about their patent listing practices. Lastly, we and DOJ are working together to finalize updates to our HSR form, which will allow both agencies to more effectively evaluate and screen transactions for potential competition issues during the 30-day window that's provided in the statutory waiting period. So those are just a few of the initiatives that we're working on at the FTC. And with that, I will hand it to Lisa.
Great. Well, I think we'll go with Doha next. I think we have Doha queued up.
Sorry,
No,
didn't mean
that's
to
okay.
usurp your authority there.
I'm happy to be the closer.
Yeah.
So I thought I was free for a second. I'm excited. So I'll echo the nice welcome that both Laura and Richard gave. It's really a treat to be here. I am a nerdy antitrust lawyer, and so I often spend time in rooms full of nerdy antitrust lawyers, and so they let me out to this litigation conference, and so it's nice to be among you. Just to kind of tailor my high-level overview a bit, I'm going to do something dangerous, which is to ask all of you a question. So just by show of hands, how many people here are antitrust practitioners or have ever handled an antitrust case? Okay, looks like maybe 30% of the room, 40% of the room. So let me start at the 30,000-foot level and get a little more granular. Antitrust is having a moment. Antitrust, used to be a little more esoteric, and gained popularity, is having a moment in the zeitgeist, and I think the reasons for that are debated, but there's no question that across the political continuum in all parts of the country, across geographies, that people are having questions about the economic squeeze that they feel. Whether you are hampered by a non-compete, which Laura and her colleagues have just taken action to address, whether you are worried about censorship online, people are looking to antitrust for questions about economic justice and economic liberty. And so all of us in the Biden administration really feel the burden of that. And as public servants and stewards of the really amazing institutions that we're privileged to lead, we have really worked hard to use the full scope of tools in our tool set to address hard questions. And I think at the Antitrust Division, we're thinking about the kinds of problems that the Justice Department is uniquely well-suited to surface and to address. And so, as Richard mentioned, I oversee a lot of programs, and it's really a treat. The public is not, the public can never truly know what a return on investment they get from the staff of the Antitrust Division, but you should know that there are, as of Monday, 806 people who work day and night to make sure that everybody, including people in this room, have a lot more economic opportunity. So in the civil program, where we think about mergers and where we think about civil conduct, we have blocked more mergers than at any time in recent history. We are more often going to court to litigate transactions that threaten competition. We are very proud of our recent victory in JetBlue Spirit because we thought that that was a merger that threatened competition in air passenger service markets, and we thought that those harms would be acutely felt by people on the lower end of the income distribution, right? So these are people who might not otherwise fly, might not otherwise get home for the graduation, the funeral, moments with loved ones, but for Spirit's low fares. We are very proud of having blocked Penguin Random House, Simon & Schuster. Books are incredibly important in terms of our economic sector, in terms of our national culture, the stories that we tell about ourselves. We felt very strongly that that is not a market that should be controlled by just 4 dominant companies, right? 4 companies shouldn't control the ideas that get published and that are distributed to Americans and people more broadly. We are seeing more companies abandon anti-competitive mergers in the face of questions from the Antitrust Division. There are many that are public, there are many that are non-public, but by my count, there are roughly 20 or so that have been abandoned since our Assistant Attorney General, Jonathan Cantor, was confirmed in November 2021. We are also very active in our monopolization cases. There have been very few monopolization cases filed since the last one that many of you have probably heard of, which was United States versus Microsoft. But in a world where antitrust is characterized by Standard Oil and the breakup of AT&T and Microsoft, you really weren't seeing these seismic landmark cases getting filed for a very long period. And it's my personal view that it's not because there weren't monopolies, it's because it was not a priority to enforce against those monopolies, and so we have made it our priority. We filed landmark cases against Google involving digital advertising technologies. Just last month, we filed a Section 2 case, that's our monopolization statute, against Apple over monopoly maintenance in 2 smartphone markets, regular smartphones and performance smartphones. And we've continued the Google search case, which was started by our predecessors in the Trump administration. And in fact, I just ran over from the courthouse where a very dedicated team is closing this morning and will continue its closing tomorrow. We are taking on information sharing schemes. We are thinking about what we call the rise of the dominant intermediary, right? Companies that kind of put themselves between people and the products and services that they use and love. The criminal program is firing on all cylinders. We are very proud of a criminal team that that indicted Teva and Glenmark for price fixing and was able to resolve that case through a novel divestiture of the part of Teva that was actually involved in the price fixing conduct, and had also secured a record fine, which is the largest criminal penalty for a purely domestic cartel. And they are filing criminal Section 2 cases. They have more grand juries open than at any time in the last 20 years. They are using a lot of tools to uncover cartel activity. And that's really important because the Supreme Court has told us that price fixing is the supreme evil of the antitrust laws. On the policy front, we are filing amicus briefs and statements of interest in products and markets that matter to people. We filed a consequential statement of interest in a case involving housing. Right, we've taken on buyer-broker commissions involving the National Association of Realtors. We have filed multiple amicus briefs involving companies that offer algorithms and software that allegedly affect the price of apartments and other rentals. And the list really goes on. And so I guess the picture I would paint for all of you is that the Antitrust Division is incredibly busy. Our priorities really haven't shifted. We have a really visionary leader in Jonathan Cantor, who came in with a vision of antitrust enforcement straight away, told the public about it, and so it's really business as usual for us this year. We're still executing on the same vision, and I think we have more up our sleeves this year. So I'll conclude there.
Great, thank you. Lisa?
I'm going to echo my co-panelists' thank you of you, Richard, and the ABA for having me here today, and thank you to all of you in the audience. I'll take a cue from Doha as my respective panelists focus on both civil and criminal enforcement. How many of you in the audience are criminal litigators or practitioners?
Okay.
All right. Well, individual accountability is our top priority in corporate and white-collar crime across subject matters for good reason. We are very focused on deterring individuals who commit crimes and orienting around corporate compliance, focusing them instead on committing to comply with the law, both civil and criminal, rather than break it. In the fraud section, which I oversee, we have 3 primary litigating units, 2 of which Richard already mentioned. The healthcare fraud unit and the market integrity and major frauds unit. We also handle all of the nation's Foreign Corrupt Practices Act and now Foreign Extortion Prevention Act work through our FCPA unit. Our prosecutors are focused, much as Doha and Laura mentioned, on many matters that influence the American economy, and the American economy is top of mind in our casework. We protect the integrity of health insurance programs, including Medicare and Medicaid. We also focus on safeguarding public fisc. We protect the integrity of markets and focus on protecting, in particular, retail investors and investors who may be at an information disadvantage to other players. And we focus, of course, on rooting out foreign corruption by companies and individuals. Across the litigating units of the fraud section, I want to focus on 3 themes that emerge through our work and our priorities. And the first, again, is using all tools available to us, in particular, proactive use of data analytics. Second, we're focused on cases that affect industries in sectors that Doha and Laura have already touched upon. And third, we're taking difficult cases to trial and succeeding. So let me now talk a little bit about each of the units and what we're focused on for this year. Healthcare itself is about 1/4 of the American economy. and rooting out schemes that involve false and fraudulent submission of claims, either to private insurers or to Medicare and Medicaid, not only drain the public fisc, but they also increase the cost of health care for us all and risk undermining the quality of patient care. In some instances of illegal prescribing, there's even a risk of death to patients. So we take these matters very seriously, and we use data analytics, these days, pretty sophisticated algorithms, to focus our resources on the worst offenders in the healthcare system, whether medical professionals or corporate executives. We focus our resources in strike forces, Richard noted, across the country, people both based in DC as across other regions. And we're now seeing these days that the average scope and scale of healthcare case we prosecute is of unprecedented size and scope. We're talking more than an average of $20 million per case based on last year's work. Some more specific priorities that are top of mind for the healthcare fraud unit for this year include Part C fraud. Medicare Advantage is the largest part and the most rapidly growing part of the Medicare program. We're also focused on corporate healthcare cases more generally. In this past year, we issued our first declination to a company, HealthSun, under the Criminal Division's Corporate Enforcement and Voluntary Self-Disclosure Policy to reward that company for coming forward to report fraud. We're focused on telemedicine fraud cases. Telemedicine, you all may know, existed before the pandemic, and it was a focal point for us then. It expands access to care, which is a positive, but it also presents an opportunity for abuse and fraud at a more rapid rate than previously was possible, and a more national rate than was previously possible. And there was an explosion of use of telemedicine during the pandemic that continues to this day. So we've brought a lot of cases involving durable medical equipment fraud, as well as genetic testing around telemedicine. Next, we're focused on risks created by private equity investment in the healthcare sector. The Department of Health and Human Services Office of Inspector General issued some compliance guidance last year, specifically calling out private equity and risks posed by pressure placed upon healthcare companies to put profits above patient care concerns. And last but not least, we continue to focus on laboratory billing fraud schemes, whether they involve addiction treatment centers or otherwise. We have a new statutory tool called the Eliminating Kickbacks and Recovery Act, or ECRA, 18 U.S.C. 220. And to date, we've brought 29 cases charging ECRA and convicted more than 21 defendants. On the trial front, we have a team in trial right now in Detroit prosecuting a doctor for telemedicine fraud involving DME. And last week, we got a conviction of a doctor involved in illegal prescribing of of orders for durable medical equipment in the District of New Jersey in partnership with the U.S. Attorney's Office there. Turning to the Market Integrity Unit, we also use data heavily in that unit, as we do in the Healthcare Fraud Unit, to focus our resources. This past year was the capstone of our initiative to prosecute spoofing and market manipulation in precious metals futures markets. We used data to build these cases, and all told, we brought 7 corporate cases, 5 of which involved major financial institutions, and prosecuted more than 10 individuals, including convicting 7 individuals at trial. Again, that includes the JP Morgan Chase traders convicted this past year. Through these cases, particularly the corporate resolutions, we require companies to commit to improving their compliance programs and preventing and detecting misconduct. Here, again, in particular, placing orders that will artificially increase or deflate the price of certain commodities. So, using the approach we successfully developed through our spoofing cases, we're now pursuing new database initiatives. We have an insider trading initiative before the SEC's rule change around 10b5-1 to target insider trading and executives who enter 10b5-1 trading plans as an attempted defense to insider trading while possessing material non-public information. Our most prominent public example of this is a case against an individual called Taryn Pizer. This case is pending in the Central District of California. He's innocent until proven guilty. But the gist of the initiative was to compare dates in which executives entered these plans against market-moving events and see perhaps why they outperformed the market. We conduct investigations using traditional enforcement techniques, but we generate these cases through our analysis of market data. Likewise, cryptocurrency fraud is a huge focus for the Market Integrity Unit and really across the department. If you all are familiar with the FBI's Internet Crime Complaint Center, or IC3, the largest form of fraud reported, and this is just from victim complaints, was cryptocurrency investment fraud. It was about more than 50% year-over-year increase from the prior year. We're actively policing fraud in cryptocurrency markets. Notably, these schemes have huge losses. In the past 3 years, we've prosecuted more than 20 individuals for cryptocurrency-related fraud schemes using wire fraud statutes, money laundering statutes, and depending on the facts, securities and commodities fraud statutes to hold them accountable for cryptocurrency market manipulation, as well as other crypto fraud schemes. Recent examples include a $2 billion Ponzi scheme in the District of Maryland called Hyperverse. We had the BitConnect case, a more than $2 billion Ponzi scheme in the Southern District of California. We prosecuted the founder of that company as well as a former promoter. And we have a whole range of other schemes, from the Mango Markets trial, where we recently prevailed with our partners in the Southern District of New York, to a case involving a token called Hydro, where individuals used wash trading to artificially inflate the volume of trades on the exchange. When there, too, we prevailed at trial in that securities fraud case in the Southern District of Florida. And last but not least, we're also using data and taking on difficult cases that have industry-wide impact in the Foreign Corrupt Practices Act unit. We've now brought 6 corporate resolutions and convicted 20 individuals in connection with bribery by commodity trading companies. That includes this year's corporate guilty pleas by Gunvor. That was a more than $600 million corporate guilty plea. And Trafigura, a more than $100 million corporate guilty plea. Our Sergeant Marine case from 2020 and our VTOL DPA from 2020. The landmark Glencore resolution from 2022. And the Freepoint resolution from last year as well. And to the point of individual accountability, again, we're bringing cases against individuals responsible for bribing foreign officials, in this instance largely officials who are employed by state-owned enterprises who are in positions to control contracts, and the bribes are paid so that business goes to commodity trading firms. We believe here, too, that these cases have had enormous impact. There was even a recent article in the Financial Times where the heads of the largest commodity trading firms said, gone are the days of paying bribes to secure commodities contracts. But our conduct has international reach. These bribes were paid in Africa, Latin America, and elsewhere. And that really came forward in our trial this February. We convicted at trial the former energy trader for VTOL, Javier Aguilar. He paid more than $1 million of bribes in order for the company to obtain benefits. Likewise, we convicted last month, separate and apart from the commodity trading firms, the former Comptroller General of Ecuador, who received more than $10 million in bribes from Odebrecht, a Brazil-based construction company that we also separately had a prior corporate resolution with. Through all of these activities, we've relied not only on our domestic law enforcement partners, but of course, our foreign partners abroad. An initiative we're really focused on at the department is building further foreign partnerships, leaving cross-border criminals fewer places to hide, and also, again, using all of our statutory tools.
Great. Well, thank you for the opening remarks. So I want to drill down a little bit on litigation. So, as I think we've talked about already, under the Biden administration, we've seen a record number of cases, antitrust cases going to trial. And so I wanted to maybe start with Doha. If you could talk us through a little bit, how you set your priorities and kind of your mindset when it comes to which cases to take to litigation.
So it's important to note at the outset that we take our cases as we find them. But I mentioned at the top that there are certain problems that the Justice Department is uniquely well suited to take on. Going after titans of industry is really hard, it turns out. And so when we were talking about the most deep-pocketed, well-resourced companies on planet Earth, some of whom are more powerful than sovereigns, we are investing heavily in investigating those cases properly, and where we think that there's been a violation of law, right, where the facts and the law support a Sherman Act violation in our conduct cases, we are going to court, and we are focused not on, again, taking a step back, I think there's sometimes a problem in antitrust litigation where there are these hyper stylized models of what competition is supposed to look like. And so then you get very stylized models of what a violation looks like. And the truth is that the world is messy. To borrow a line from the district court in the US v. Microsoft case, the means of illegal exclusion are actually too myriad to mention. And so for us, that means that we really need to be faithful to the facts, and we need to be better storytellers and bring to life, often before a hardworking federal judiciary, excuse me, of generalist judges, some of whom may not ever have touched an antitrust case, we have to make our concerns real to them. And so in, again, JetBlue Spirit, we focused on, this idea of the hypothetical consumer who's cost conscious, who's not going to get on a flight if they can't have Spirit's low fares. In the Penguin Random House Simon & Schuster case, we put on literary agents who talked about how they focus on getting author advances and opportunities to publish books for people who otherwise would never have their stories told. In the Google search case, we talked about privacy degradation. We put on witnesses who talked over and over again about how, notwithstanding resources and investment and intellect and talent, they couldn't make a go of a rival search business because Google had made the market so, right? And so that's how we're telling stories about structural problems in the market when monopolists engage in exclusionary or predatory conduct. In our criminal cases, which, as you guys know, are often tried to juries, we've seen successes and we've seen setbacks. And I think I speak for our entire front office that we take all of that in stride. It is very, very important for us to be responsive to the feedback that we're getting from judges and juries, and we are. And so we know that the enforcement landscape is sometimes a little more difficult. Jurors might be suspicious of government prosecutors. And again, that is okay. That is our constitutional system. But it just means that we have to work harder to make the violations that we're seeing real. In our criminal cases, we're using Title III wiretaps more. We have changed the terms of our leniency policy to really prize real cooperation, right? Not the wishy-washy, half-hearted cooperation, right? That really makes it harder to try cases. And we are also using plain language to explain to judges and juries why price fixing is basically like theft, right? Why wage fixing is a form of theft. And it's been really wonderful to see the division really get back to full strength litigating both civil and criminal cases. And I think a lot of that credit goes to my colleague, Heil Doshi, who helped build out our vision for a litigation program. So again, we have hundreds of really talented prosecutors who are trial attorneys in the Antitrust Division, but we've stood up a program called the Litigation Program with senior litigation counsel who are extraordinary. Some of them come from elite defense side law firms, some of them are plaintiffs' lawyers, some of them came from DA's offices, some of them came from US attorneys' offices. There's an individual who has tried 120 cases to a verdict. There are Blagojevich prosecutors. There are people who have taken on the Leviathans. I mean, they are really incredible, and their superpower is that they are not only formidable first and second tier trial lawyers, but they're really teaching. And so when we think about enforcement and litigation, I'm really proud of the impact, right? Like the dollar volume of commerce, where we can credibly say that we've improved competition meaningfully. But internally, we're also seeing young people getting more at bats, taking witnesses for the first time, sometimes crossing CEOs, sometimes taking on expert witnesses. And it's really a wonderful thing to see, particularly when you see younger people, women, people of color, really getting opportunities to stand up and try cases.
Great, thank you. Laura?
Yes. So from an enforcement and litigation perspective, we have several priorities that we emphasize in selecting which cases to bring and how to pursue them. First and foremost is probably deterrence, right? We want to use the full range of tools that we've been given in order to deter anti-competitive conduct. And so that includes both, as Doha said, thinking creatively and flexibly about what anti-competitive conduct looks like and what anti-competitive transactions look like in these complex markets. But it also means showing a willingness to take on hard cases and go the distance and litigate where necessary. Another priority for us is in crafting remedies to look upstream and get at the root causes of threats to competition as opposed to putting Band-Aids on and moving on. We also, in the same spirit, we really look to intervene in nascent markets before they reach a tipping point. We did that in our IQVIA litigation and in the Illumina case, and we really seek out markets where we think we can make a difference before they have tipped to a dominant player. The Bureau is also working to reinvigorate Section 5. We see that in our pesticides litigation investigation against Syngenta and Corteva, and the Section 5 count in our Amazon case. And over the last year, we've been extremely busy. We have brought cases to block acquisitions in markets involving healthcare data, hospitals, including a case to block a hospital acquisition by Novant down in North Carolina, where our team is at trial right now. We've also moved to block the largest supermarket merger in U.S. history, and where we're also in that case including the first Section 7 theory relating to harm to workers. We've had several investigations that have led to abandonments over the last year, and others that have led to consent orders post-complaint. We also continue to have an extremely active docket of conduct cases in federal court. Just to name a few that you may have heard of, we are litigating a challenge to Meta's acquisition of Instagram and WhatsApp in DC federal court. The pesticides case that I mentioned, which is the first case the agency has brought under Section 3 in decades. We brought a challenge to a private equity roll-up of multiple anesthesia practices throughout Texas. And we've also filed a lawsuit against a small company called Amazon, challenging numerous aspects of their practices in the online marketplace. We've also been very active in enforcing remedies, both in administrative and federal court orders. There's the 7-Eleven case, but also earlier this year, the Second Circuit in FTC v. Shkreli affirmed the district court's decision to impose a lifetime ban under Section 13B on Martin Shkreli's participation in the pharmaceutical industry and finding him liable under New York law for disgorgement. Finally, our Bureau's Criminal Liaison Unit continues to work closely with DOJ Antitrust Criminal Enforcement Division and collaborate on that front.
Great. So I want to shift gears a little bit. So I think, when we talk about litigation, as Doha said, you kind of take the cases that you have in front of you, but I think there's an aspect, and Doha, you touched on this, of, what are the best approaches to developing the facts you need to successfully litigate those cases. And so I think what we've seen recently has been a shift in approach at DOJ in terms of an expansion of the tools being used to detect misconduct, to bring those matters in earlier, including the recent announcement of a whistleblower pilot program. So Lisa, I was hoping you could talk to us about the whistleblower program, the pilot program, the impetus behind it, and what you're seeing and hearing as you try to sort of put it in place.
Absolutely. So you mentioned, Richard, tools to identify misconduct. It's exactly that. These pilot programs, the whistleblower sprint announced by the Deputy Attorney General, as well as our criminal division's individual voluntary self-disclosure pilot program, and similar pilot programs announced by the Southern District of New York and the Northern District of California U.S. Attorney's offices. They're all, of course, oriented on individuals coming forward to the department, bringing in original information about corporate wrongdoing to our attention. Now there are new incentives, and there's more transparency around the incentives than I think ever existed before, not only with respect to these new programs that offer incentives for individuals, but also our corporate enforcement policies. As you know, Richard, from your time at the department, including before you left, we recently revised across the department our voluntary self-disclosure programs, and the Antitrust Division has a long-standing leniency program. I think it's, at this moment in time, more clear than ever that we are being transparent about the massive incentives available to both companies and individuals to come forward and report crime. I would also say that these programs are mutually reinforcing. We've long heard from counsel for companies that it weighs heavily on them in the decision whether to come forward and report to the department their analysis of the risk that the department will learn about the wrongdoing from some other source. And the whistleblower sprint, as well as the individual voluntary self-disclosure programs, create higher risks, to put a thumb on the scale, for companies to make the decision to invest in their compliance programs in the now, to make a commitment to a speak-up culture, to make sure they have robust internal reporting, so they have an incentive to find out about misconduct and address it before it becomes a big problem or a crime, and certainly before whistleblowers come to us. So that's the impetus for these programs. But let me get down to brass tacks of what each program entails. So starting with the whistleblower sprint, this was announced by our Deputy Attorney General at the ABA conference in March. I should note that our program isn't live yet. We're very much actively in the sprint. Well, I managed to not be spreading, I promise, along with my colleagues at the Criminal Division. The sprint is led by the Money Laundering and Asset Recovery section, and my section, the Fraud section. And so we're focused on, right now, hearing from colleagues within the department, feedback from other stakeholders in terms of the whistleblower bar, white-collar defense bar, regulatory agencies and others, academics, and trying to make a thoughtful program that we'll recommend to the Deputy Attorney General. It will go live later this year, but it is not yet live. However, what's already been announced in terms of guideposts by the Deputy Attorney General, and these are things that we're studying now, are that this is a program that offers a prospect of money, of financial compensation. That is the main reward for whistleblowers under the whistleblower sprint. The money will be paid as a percentage of criminal forfeiture. We have specific authority under 18 U.S.C. 524 for the Attorney General to pay awards for information or assistance leading to civil or criminal forfeiture. So that's the source of the money. We're looking at whether there should be a threshold associated with the cases. Similar programs from the SEC and CFTC do have thresholds, so we're assessing what a threshold should be. The information provided by whistleblowers in this program must be truthful and, of course, complete. The Deputy Attorney General also announced that only individuals who are not criminally liable would be eligible, and that we'd offer payments only after victims, if there are victims in the relevant offenses, only after the victims have been appropriately compensated. Something we're also keyed in on is examining whether we'll have the whistleblowers be required to first report internally to companies before reporting to DOJ, and if so, how far in advance they might do so. The key types of offenses highlighted by the Deputy Attorney General that will be part of the program include information about criminal abuses of the U.S. financial system, domestic corruption cases, and foreign corruption cases outside of the SEC's jurisdiction, especially cases that don't involve issuers. It's no secret that there are other very successful whistleblower programs out there, particularly the Dodd-Frank programs by the SEC and the CFTC. There's also the False Claims Act. IRS and FinCEN have whistleblower programs. We've used these programs working in parallel with our partners to successfully build scores of cases. And these programs have paid out huge reward to whistleblowers over time. But we're looking to fill gaps in the existing programs through our whistleblower sprint. And the last example I just mentioned, non-issuer cases involving potential foreign corruption. That's a key area. We've heard from the SEC and from Whistleblower Counsel that they'll get complaints about foreign corruption for non-issuers, and yet there would be no path to recovery for them because non-issuers aren't covered by the SEC program if they were to come forward and report in the status quo. So we're sprinting. We don't know the full contours of the program yet, but we're actively deliberating about it, and the best programs result from thoughtful process with consideration of other perspectives, and that's exactly what we're going to do here. Turning to the individual voluntary self-disclosure program, however, I wanted to say, to keep the terminology clear, the whistleblower program offers money And the individual voluntary self-disclosure program offers the prospect of a non-prosecution agreement. So, who is it for? It's for individuals who come forward who believe or actually have some criminal liability. And we are seeking to provide more transparency around the circumstances under which we will provide non-prosecution agreement to such individuals who, again, come forward and provide original information about certain key priority areas. And furthermore, these individuals, of course, have to have the ability to substantially assist and cooperate in our investigations. The areas we're focused on here are a little bit broader. They include, again, schemes involving financial institutions, schemes related to the integrity of financial markets, foreign corruption cases, healthcare fraud and kickback cases, federal contract fraud cases, and domestic corruption schemes. This program is not for everyone who commits a crime, however. We've carved out certain categories of individuals, such as CEOs and CFOs, individuals who occupy positions of trust, such as domestic public officials or foreign officials who are elected or appointed. I mentioned earlier our commodity trading companies cases involving bribes to officials working at state-owned enterprises. We appreciate that there's a difference in some individuals who have positions that are elected and appointed versus others, but we're looking closely at all tips that come in through this program. So we have a web page dedicated to the pilot program that tells you how it works. I recommend that you go there and check it out on our website, and there's an easy portal for submission of a complaint. If you'd like to do so as counsel, you can do so as counsel, or of course, whistleblowers can directly report on the portal about crimes. I should close this out by adding, when we evaluate a corporate compliance program in the context of a criminal investigation, we're also looking at not only whether there's a speak-up culture and internal reporting mechanism, but we're looking at whether companies take seriously training on whistleblower programs that exist, the SEC programs, and whether there's a commitment to not retaliating against whistleblowers too.
Great. So we got about 10 minutes left, and so what I want to do is turn to talk about compliance programs. So it's sort of a great segue there, Lisa. And so, I think one of the points of emphasis we've seen over the last few years from the department and from the FTC has been on the use of ephemeral messaging, collaboration tools, and the like. And so, I'd like to talk about some of these developments, the reasoning behind them. I mean, we've seen frankly, some court filings lately that have touched on these issues. Laura, I'm looking at you, and so, it would be great to hear from you all about, the emphasis on these issues in compliance programs. Sort of what should companies and in-house professionals be thinking about, and where the risks are. And I think the last point would be, any examples you can give where you've come across this and what's animating the concern. So again, we got about 10 minutes left. So Lisa, we'll start with you, and then turn to Doha and Laura.
As I mentioned, our corporate enforcement policy incentivizes voluntary self-disclosure by companies and offers a key reward of a presumption of a declination for companies that come forward and fully cooperate, timely and appropriately remediate, and disgorge or pay any restitution associated with the offense. It's a huge benefit to receive a declination from the department as a result of bringing forward information about a crime. To fully cooperate, one of the requirements is being able to timely preserve any relevant evidence and information. And companies have fared better if they've gotten their arms around ephemeral messaging issues by doing so. Two recent examples are declinations for Corsicol and for HealthSun, where the companies were able to retain information that was of use to cooperate with the department in our investigations, so that we could hold other individuals accountable as a result of them coming forward. We revised the evaluation of corporate compliance programs framework that we use to analyze corporate compliance programs more broadly to focus in on ephemeral messaging issues as well. So it's not just with respect to cooperation, it's also with respect to compliance that we're keyed in here. And it is not enough for companies to throw up their arms and say, this is a difficult issue, we don't have a plan. What we're really asking companies when they come to us is, have you taken into consideration the key risks that your business faces when you're fashioning an employee device policy? What we've seen so far after making edits to our ECCP document to this effect is that companies in highly regulated industries, such as big banks, have mandated use of company phones, and there have been enforcement actions by SEC and CFTC about off-channel messaging as well. Not all companies can do that, however, and they face different risks. So we've seen other companies mandate only for certain classes of employees, for example, they use companies' phones. We also like to hear lessons learned from things that companies have attempted that haven't succeeded, but overall, the key thing is that we want them to be thoughtful about their approach in devising ways to retain information because it's critical to them as well as us.
Great. So I'll turn to Doha.
Sure. So I want to pick up on just a thread of this that is very important and reflect on how we're experiencing a particular compliance issue with the Antitrust Division. In January of this year, the FTC and we issued a release notifying the public that we were updating standard preservation letters, grand jury subpoenas, civil investigative demands, and so forth to update specifications about not only the need to preserve documents, but specifically focusing on ephemeral messaging. And so I think the most commonly sort of used available form of ephemeral messaging is Signal, for example, right? So it like automatically deletes. And we're seeing more issues with this in our investigations. And the concern, of course, is that if a company is under federal investigation and communications are being deleted, it threatens the integrity of our investigatory process, which raises the specter not only of spoliation problems, but in the worst sense, obstruction problems. And so one public example of this that I'll describe in limited detail because it's related to pending litigation is the sanctions motion that we filed in our Google search monopolization litigation. There, the department alleged that Google had two policies that really caused it to fall down on its preservation and ultimately production obligations. One related to these kind of silent attorney emails where they were using attorney-client privilege headers, adding attorneys to communications and so forth without a real expectation, as the department has alleged, of getting legal advice and then not turning those over. And so that was the subject of motion practice last summer. Separately, a big issue that came out at trial was over chat destruction, right? You had key witnesses, again, who had been subject to legal process, saying, let's go off the record, right? And moving to platforms that were not preserving communications. And that raises, again, concerns because when you're actively investigating and litigating, the government may not get documents that it is lawfully entitled to as part of an investigation. I'll stop there because, again, it's subject to pending litigation. Again, closing arguments are going on this morning. But I think for all of you who are thinking about compliance, those of you who are practitioners, defending companies who are involved in investigations and litigation, this strikes me as a really important thing to get right. The consequences of falling down on these obligations are extraordinary. And again, in the worst cases, the threat of obstruction charges loom large, which in some cases carry heftier penalties than a Title 15 violation, which is where the antitrust statutes live.
Great. Laura?
Yeah, so, tools that are used in business are constantly evolving with technology, and so our enforcement tools are evolving along with it. And that's part of why we at the FTC joined the DOJ in messaging out to companies that we are tracking the increased use of ephemeral messaging and other collaboration tools, and that we consider that very much part of the record that needs to be preserved when there's a federal investigation. And we've updated our model second requests and model CIDs to reflect that. And yet, we continue to see instances of this going on. In fact, just last week, we filed a motion in the Amazon litigation seeking to compel Amazon to produce documents related to that company's alleged failure to preserve its signal messages. And we brought that motion and alleged that for years Amazon's top executives used, including Jeff Bezos, discussed sensitive business matters, including antitrust issues, over Signal, and that they turned on Signal's disappearing message feature after they knew that we were investigating their conduct. And that feature irrevocably destroys those messages. And so we are taking initial steps to find out the extent of what went on there and to seek civil remedies. But no doubt that this is just one example of many. And so that is why we have made this a priority to message to folks who are counseling clients that they need to have this on their radar and that we will be looking for this type of conduct.
So we've just got a couple of minutes left. I think we'll maybe go down the line and just give any closing parting thoughts. And if you want to include in that anything about, we've heard a lot of, obviously with the DOJ and the FTC, there's the overlap, but with the criminal division, anything you want to share in terms of how you collaborate and work together, that'd be great.
Starting with me?
Yeah, we'll start with you.
Sure. So, look, parting thoughts, this is a really exciting time in antitrust. We're incredibly busy. We're really proud of the work that we're doing. There's so much more to be done. Looking ahead, the things I'm most excited about are thinking more about information sharing. I gave a speech last February talking about how information sharing and some safe harbors that used to be on the books over at the Department of Justice is really a threat that we haven't fully appreciated. And the availability of data at scale, concerns about frictionless information sharing, and the availability of modern day tools like artificial intelligence and machine learning, I think have really caused us to underappreciate the real threat that information sharing poses. And I think you can draw a straight line from information sharing to algorithmic collusion. And so I'm hugely excited about that space. In terms of collaboration, I think one of the high points of our time in the administration has been the amount of collaboration, not just within the Department of Justice, but with our sister executive branch agencies. So the Antitrust Division is just one tiny component in a Department of Justice that is 110,000 people strong. I really enjoy getting to collaborate with Lisa, for example, and seeing how they're dealing with serious challenges down the hall, or I guess one floor down. When we're thinking about our hardest cases and setbacks that we face, I think we draw a lot of inspiration, for example, from the criminal division's success, really rooting out spoofing cases. And have even poached several of their prosecutors to bring into the Antitrust Division to help us.
We no poach, I understand.
We are pro-poach, to be clear. Internally, that's just one example of the many ways that we get to collaborate with each other, and so it's really a treat. Enforcement can be lonely work, and so it's nice actually to have a sister agency that also does competition enforcement, and so the relationship between the Antitrust Division and the FTC is actually very good and it's strong. And one topic that is really a big deal in antitrust world that I will share with all of you is that the president signed an executive order on competition stating that it shall be the policy of the Biden administration for agencies to coordinate and collaborate on competition issues. And it turns out that antitrust doesn't just live in Title 15 or in Section 5 of the FTC Act. The U.S. Department of Agriculture has something called the Packers and Stockyards Act, which is a competition statute that looks a lot like Section 5 of the FTC Act. The Federal Maritime Commission has competition authority. The Surface Transportation Board, which deals with railroads, has competition authority. My favorite competition statute in an odd place is the Panama Canal Act will not allow a vessel to pass through if the owner of the vessel has been convicted of price fixing. under the Sherman Act. And so there are all of these competition statutes that dot the United States Code, and so it's a chance for us to kind of link arms and share experience with sector regulators. So this is really, it's a cool moment for the admin.
So I think we have 30 seconds
Sorry.
For a piece for Lisa and Laura.
Wholeheartedly co-sign what Doha said. It's a privilege and an honor to represent the United States every day, but to get to work with colleagues like Doha in the Justice Department and colleagues like Laura and other agencies is a true pleasure. I do want to say one specific thing is, our Deputy Attorney General has really been a thought leader in the corporate crime space and many other spaces, but by setting early in the administration our corporate crime advisory group, she got together leaders in the white collar space across the department, and we've all remained in touch. So what does that mean for your clients? It means we're a united front with respect to rewarding the good, but also punishing the bad, especially given the broader definition of corporate recidivism, where we look at a company's history of civil, regulatory, and foreign and domestic conduct, again, criminal and civil. We are talking to our colleagues all the time about a company's history to understand its culture. We are talking to each other all the time to determine if new conduct breaches our corporate resolutions. And we are also having fun doing it because, again, everyone is really talented and professional. So thanks, Richard.
I just saw the scary red sign that says we're out of time, so I will simply say that I second everything that Doha and Lisa have said, and that collaboration is the key to our success. So, thank you very much.
Well, thank you to our panelists today. Please join me in giving a round of applause.